Good evening, everyone. Welcome to Alumni University. Thank you all so much for joining us. We are so happy to have Professor Nancy Kim presenting tonight. Apologies. So just a few housekeeping notes before we get started. So please note that this presentation, including the chat, is being recorded and will be available on our website in the next several weeks. Additionally, if you have any questions throughout the presentation, please type them in the chat box at the bottom of your screen, and we will do our best to get them answered at the conclusion of Professor Kim's slideshow tonight. So to introduce our presenter, I am so happy to have Professor Nancy S. Kim. She is the inaugural Michael Paul Galvin Chair in Entrepreneurship and Applied Legal Technology here at Illinois Tech. Professor Kim's scholarship focuses on consent, contracts, privacy, and the effect of technology on society. So I will turn it over to her to get started, and we are so happy to have her joining us this evening.
Thank you. I'm so excited to be here and to talk about my research. Let me get the screen share going here. Okay, so again, my name is Nancy Kim, and I'm the Michael Paul Galvin Chair in Entrepreneurship and Legal Innovation at Chicago-Kent College of Law at Illinois Tech. And today I'm going to talk about my current research project. And it's on something that you are probably all familiar with, but you probably haven't given much thought to. And that is all the fine print that controls the internet and what we typically refer to as TOS, or Terms of Service. And I'm going to talk about how terms of service have shaped the internet and how they control much of modern society. I've written extensively on contracts and consent and the issues that arise when technology and businesses using new technologies move ahead of the law before regulators and legislators have a chance to address some of the issues that they pose. And I've written about these issues in dozens of scholarly articles and in 3 books. I recently moved to Chicago from San Diego for my new position at Chicago-Kent, and I'm thrilled to be here. Okay, so let's talk about the fine print online. The internet is not new at this point, and neither are its problems. But what is new is public awareness of just how widespread and varied these problems are. There's been a lot of attention paid recently to the misinformation and the disinformation that is online. The question is, how did we get here? And what does this have to do with terms of service? Okay, so let's start at the beginning. And by the beginning, I mean the beginning of the internet, but not the very beginning, not the World Wide Web, but let's say 20, 25 years ago, when most people were just starting to get online, when we really started to get mass public adoption of sort of the online services. At that time, what was permissible for companies to do online with respect to consumer data? Because remember back then, it wasn't clear how people were going to make money using the internet. I mean, sure, some businesses could sell goods to people online, although at the time, you might recall that people were very wary about giving a complete stranger access to your credit card number, if you can remember that, okay. And there are other business models being tried out. For example, would people pay for content? Would a subscription model work? And then there was a good old a TV model, where content would be provided for free and advertisers would pay to place their banner ads on websites. Okay, so with respect to that business model, what could companies do? What was it permissible for them to do? Was it okay for them to install cookies, bits of code on computers and follow their visitors around from website to website. It wasn't clear, but they didn't know that marketers liked this information and they could make some serious money this way. But it wasn't clear that this was legal or ethical, but it also wasn't clearly illegal. And most of the public at that time, 20, 25 years ago, they weren't even aware that this technology even existed. Okay, so under the law, if you're not sure whether what you're doing infringes upon someone else's rights, typically you ask for permission, and that way you can be sure that you're not infringing upon their rights. Because if they give you permission, if they consent, then under the law, provided that they are of age and in most circumstances, if they consent, you've done nothing wrong. So if, for example, I ask if I can have something of yours and you consent, then you've given me a present, okay? You've given me a gift. But if I ask you and you say no, or if I just take it without asking, then that's stealing and I've committed a crime because you did not give me your consent. Okay, so generally, how do we obtain consent? Well, in person, we can give it verbally or through our actions. And in a business context or in a commercial transaction, typically consent is given in a contract. But what exactly is a contract? Okay, so let's start with the lowly contract. When most people think of a contract, they think of a piece of paper that's negotiated and signed. Okay, and that is the standard contract scenario that the law contemplates. And that often happens in a business context. But as society modernized, more contracts became standardized, especially when they were transactions with consumers. And consumers weren't able to negotiate different terms. These standard form contracts were called adhesive contracts because they were offered to consumers on a take it or leave it basis, meaning that the consumer had to stick to the terms or they would have to walk away. Okay, so the need for standard form contracts was because with industrialization and the standardization of products, it was more efficient. So companies didn't have to negotiate terms with each individual consumer. Okay, so that was all okay. I mean, there were issues with that, but okay. And then we saw the form of the contract change. In the early days of mass software products, this is when software came loaded on CDs, we saw shrink wrap agreements. Shrink wrap agreements, well, they're called shrink wrap agreements because they are wrapped in plastic wrap and they are contained in the package with the CD. And at the time, the early days of mass software, companies wanted to be sure that their customers wouldn't make copies of the software and distribute them to friends because that would really undermine their business model. And under the law, if you buy a product, you have the right to sell your particular copy of that product. I'm sort of simplifying, but that's basically going to be the case. But if you contractually agree that the transaction is not a sale, but it's a license, and if you restrict somebody's ability in a contract and they agree to it, then they're not allowed to resell and make copies and resell that piece of software. Okay, so we started to see shrink wrap agreements. And then came mass adoption of the internet, and we started to see the form of contracts change again. I don't know, there aren't too many of this form around, but circa 1998 or so, there were most of the agreements were these type of scrolling kind, where you scrolled all the way to the bottom and then you clicked accept. Sometimes you saw this form, which was the hyperlink. This was called a browse wrap. So you click on the hyperlink and it takes you to a page where there are legal terms. And then we started to see different forms, the multi-wrap, where you click and then there is a hyperlink. So it's kind of a combination of the clicking function, the click wrap, and then the browse wrap. Okay, so here again, you click on something, but the terms are actually behind a hyperlink. So you don't, the company doesn't make you scroll down before you accept. And then of course, with phones, we see the form of the contract migrate to this particular format in a lot of cases where you click register, but in doing that, you presumably agree to the terms of service that are here at the bottom and hyperlinked in blue. Okay, so with all these changes in the form of a contract, the question was, were these digital wrap contracts really the same as paper contracts? Should we recognize these forms as valid contracting forms? And courts said yes. They would make these comparisons to paper contracts and say, for example, that a hyperlink should be treated the same as a multi-page written paper contract. The blue hyperlink simply takes a person to another page of the contract, similar to turning the page of a written paper contract. And another court said, a person who checks the box without reading all the terms on the website, it's just like somebody who turns to the last page of a paper contract and signs it without reading the terms. Namely, the clause is still valid. But the courts seem to ignore that there are some very important ways in which paper contracts differ from digital contracts. And those ways affect how the parties use the contracts and perceive the contracts. So paper, of course, is tangible. There's a weight to it. And because it's tangible, it has certain effects. First of all, it's more costly to produce. I mean, you have to make copies of paper if you want to distribute them to all your customers. And if the contract is very long, the consumer can feel how heavy the contract is, even if they don't actually read the terms. And people are generally suspicious of very long contracts, especially for seemingly unimportant transactions. Of course, there were contracts for a lot of transactions that consumers didn't read, that were intangible form, that were not necessarily paper contracts. For example, tickets. A lot of times there were terms on the back of tickets or claim check tickets or vouchers. But the terms were constrained. They were limited to the space available on the back of that ticket. And so all of this had certain signaling effects and certain limitations on businesses' willingness to impose contracts on consumers. With digital contracts, those signaling effects are gone. Digital contracts are, of course, intangible and weightless. And so reproduction is basically cost-free. And because it is, terms can be updated much more frequently than with paper contracts, where you would have to then throw out all your old paper contracts and then print out new copies of your modified terms. Nope, that's not an issue with digital contracts. They're also, because they're weightless, they're invisible to the consumer, which means that there is no loss of goodwill when a business asks a consumer to sign a contract. And because there is no visibility as far as the consumer goes, and there's not a huge loss of goodwill, and because of that, companies were able to impose more aggressive terms because consumers weren't reading them anyway. And they were imposing them for more types of transactions not just for important transactions like buying a house or transactions where the business had some sort of a property interest. For example, a car rental agency would want you to sign a contract because you're driving off with their car. So it made sense that they would want you to agree to certain contractual terms. But online, there was no distinguishing the nature of the transaction by the contract, because contracts were being imposed on consumers for all types of transactions and by all types of businesses, because the signaling effects were absent. They were also presented differently in that with a paper contract, you typically sign at the end of the contract. And so even if you don't read all the pages, you know how thick the document is. You know, if somebody hands you a stack of 50 pages when you buy a shirt, that this seems suspicious. This doesn't seem right. Okay. And you could also skim paper contracts. Even if you didn't read, you could skim to see if there were any terms that were in bold that would jump out at you. With a digital contract, you're often asked to sign at the beginning. And it's difficult to tell how long the contract is because of the way it's set up. Most people don't actually click on the hyperlink and scroll through and read the terms. And it's also very difficult to skim to read to see which terms are in bold or in caps. The result is that today we have more contracts than ever for more types of transactions. And the contracts are longer and the terms are more aggressive than they used to be offline. Because they're digital, most people don't even think about them or notice them because they're weightless. Also, because they're digital, they can be updated more frequently. So the consumer is never really sure what, there's really no point in reading them anyhow if the terms are going to be updated so frequently. And of course, the company doesn't have to print out new versions and distribute them to their different locations, their different offices. And the result now is that for even relatively simple transactions, the consumer is often agreeing to what would be pages and pages of terms. And this was not something that was an issue in the past. And everybody knows that nobody reads contracts, digital contracts. And there is a sort of a cycle here, because the more contracts there are, the more habituated consumers become to seeing them, the less likely they are to notice them. And then companies don't have to hold back. They can use more contracts with more onerous terms for more transactions. But these problems of contracting form aren't just about the way a contract looks. They've also created real problems of substance. And this is because consent is often obtained through a contract. And contracts these days are often entered online with a click. Okay, and what this means is that more people are agreeing or consenting to more things without being aware of it. And these things to which they're agreeing become increasingly and in the aggregate more important. And this has really changed it has really shaped the internet, and it's really changed a lot of our norms, both online and offline. And that's because, again, contracts often fill legal gaps, places where the technology moves ahead of the law and businesses aren't sure whether or not their model or particular business practice is legal. So if they're able to obtain the consumer's consent, then they are protected from a later claim by the consumer that whatever the practice is violated their rights. Furthermore, consent provides a defense to many federal and state laws. Okay, so let's look at the example first of privacy, of how terms of service have shaped online privacy, which has then affected our offline lives. So it wasn't clear, again, 25 or so years ago, what was permissible for companies to do online with respect to consumer data. Was it okay to collect data about them? Was it okay to share it with third parties? Was it okay to do things like scan people's emails? Well, if you're not sure, you can ask for permission, and if they consent, then okay, you're probably going to be safe. But when consent is in the form of an online contract, it's not always easy to figure out what it is that you have consented to, because you would actually have to read the terms and click on all the hyperlinks contained in the terms. And companies design their contracts to encourage the clicking, the manifestation of the consent, while actually discouraging the reading of the fine print. So here you see that you can sign in, and then the hyperlink to the terms is separate. It's not like in the days of the scroll wrap, right? Where you had to scroll, and nobody liked scrolling. But you know what was great about scrolling? It's that it was so terrible. So companies knew that if they gave you 100 pages of terms, people would be onto them, right? Their visitors would be onto them, and they would think, what is this? Maybe they would just move on to the next site, because who has time to sit there and scroll? Okay, so this has become a very easy way to get consent without having to be transparent about the terms. The result, of course, is that consumers might have inadvertently consented to things that they maybe didn't want to. Okay, so you might wonder, does this really matter? Is it a big deal if Google or Facebook has your data? They're just using it to sell you stuff that maybe you want anyway, right? Well, not exactly, because the more information, the more data that's out there about you, the more vulnerable we are to all sorts of bad actors. Let's take the case of internet-connected toys, because the contracts don't just govern social media sites. They also govern products, including smart toys. A few years ago, the FBI issued a report about the dangers of internet-enabled toys. And they said that these dangers include child identity theft and exploitation, and even physical security, because some of these toys were GPS enabled. And what do they suggest as the precaution that consumers take? Well, they said, you should read the user agreement disclosures and privacy practices. But that is a really heavy burden on consumers to protect themselves. Combine that with improvements in voice recognition and the other advancements in technology, and the privacy implications become much more profound. Because the information that companies collect about you, despite what companies may say, may eventually, or maybe inevitably, end up in the hands of third-party marketers. And the more companies that have access to your data, the more susceptible they are to bad actors, because even the biggest tech companies have been hacked. So they say, don't worry, we don't share customer identifiable information. That doesn't mean they don't sell customer information. They just don't sell customer identifiable information to third parties but they say without the customer's consent. But that's exactly the question. What do companies mean when they say without your consent? Do they mean your consent when you clicked to agree to the terms and their privacy policy? Well, when they get sued, that's what they turn to, and they say, no, our users consented because they clicked to our terms. And we know this because they use the word consent when they want consumer consent. But so they'll say, for example, we don't share information without the customer's consent. But if you need to get the company's consent, they make clear that you need to get their express written consent. So they're differentiating between this blanket consent that you give when you click and the specific express written consent that you need to get from them if you want to use their logo or whatever it might be. Okay, so I'm going to talk a little later about how this clicking and all the terms of service have enabled the surveillance economy, right? The data collection economy and what impact that's had. But it's not just in the area of privacy that terms of service have changed our society. They've also changed business norms. They've done it in a lot of different ways, but I'm going to focus on two clauses that have become prevalent online. The first is limitation of companies' liability clauses, and the other is how they have changed business models in the fine print. Okay, so the second one I need to explain further, but let's talk about the first one. First, companies may have an actual limitation of liability clause. Often, before the internet, or when you buy something from a store, the product is subject to implied warranties under the Uniform Commercial Code. But you are permitted, you meaning that the retailer is permitted to disclaim warranties. Okay, but usually when you buy something at a store, you're not signing a contract, so there's no issue about a warranty disclaimer. And so if you buy a shirt and you take it home and there's a huge rip in it, you can bring it back because there's a breach of the warranty. Okay, but if you buy the same thing online, you've probably agreed to a contract that disclaims warranties and limits the company's liability. Another type of clause that tends to affect a company's liability or the extent of the liability in terms of their reputation is what's known as a mandatory arbitration clause. So these clauses specify that if you have a dispute with the company, with the business, that you agree that you are going to take it to a private arbitrator as opposed to suing in a court of law. The result, of course, is that if there are business practices that you are suing over, if they're adjudicated in a private forum, then the public isn't really going to hear about it. Okay, so let's move on to how terms of service have changed or reshaped certain business models. So what does this company do? Well, it's Uber, and try to think about what you knew about the company 3 years ago, okay, before all the focus on workers' rights. Okay, so 3-4 years ago, Uber, their ads say start riding with Uber, always the ride you want. So you would think that it was a company that provided rides. It was a transportation company. But in the fine print, they make clear that no, they are merely a platform company, not a transportation company. Despite what it might say on their website. Say, we provide the ride you want, you rate, we listen, tap a button, get a ride. It's not transparent that the drivers are not their employees, and the company is going to claim they're not liable for what their drivers do. So they want you to trust their drivers, but in their fine print, they say, we don't guarantee these services. We're just a platform. So we don't guarantee your safety or anything. Okay. They're not the only platform company to do that. Airbnb looks like they provide you with homes or places to stay. homes that you can stay in, right? But in the fine print, they make clear that no, they don't own any of these properties. They don't have any control. They don't guarantee the quality of them. And so when something terrible happens in one of these properties, somebody gets assaulted, there's a lot of publicity focused, and the company will come out and make a statement that safety really matters to us. We really care about your safety because it's bad PR. But in the fine print, they say, we're not liable. We have no control. We don't guarantee the truth or accuracy of any listing or the performance or conduct of any member or third party. So they can advertise one way, and in the fine print, they say something completely different. All right, another business model that's changed. So that was the platform business model. It's another type of business model that was shaped by fine print was the selling of products. Now you license a lot of products that you used to buy. So books, when you buy a book and you finish reading it, you could give it to a friend, or you could sell it online because you have, under the copyright laws, a right of first sale. So you can sell your copy. But if it's a license, you can't do that. You're limited, unless of course the license allows you to. Okay, so there are certain restrictions you have because you don't actually own the book, you're merely a licensee. And there might be certain conditions to the content, and the company may be able to delete the content if you stop the subscription service, even though you might have paid as much for that ebook as you would have for a physical copy of the book. All right, so there have been a lot of new business models that have come up that have changed existing industries. So fine print and technology are reshaping existing industries, and they're really changing the business landscape. This is when it comes to book, the publishing industry, music, journalism. And let's talk about journalism now. So with free content, companies were able to thrive by providing free content because they didn't have to worry about making money by selling subscriptions the way newspapers did, because they could sell data instead. And also newspapers also sold ads, but the sort of content provided online moved away from simply providing banner ads to selling more personalized ads, data or access to data. Okay, so that was data that the customer consented to in the term when they agreed to the terms of service. So unlike newspapers, which had to pay reporters and had to worry about subscription fees and ad dollars, where the cost to the consumer was made transparent, with free content, the cost wasn't transparent. And so ad dollars moved to online content providers. The economics changed, and they were shaped in part by the rules created by terms of service. So what happened was reliable news sources started to disappear because they couldn't compete with free. But free is not as reliable. And so the result has been less reliable news, more information about the visitors, more data about the visitors to a particular website, more information that companies can use to personalize advertisement and content. So it's not just ads anymore. It's also now other people willing to promote certain content to you because now they know more about you. So there's now more ways to be used, tricked, and exploited. And we've seen now what happens. It's not just about buying stuff anymore. It's actually about real things that affect our society and our democracy. The information that we get in order to, as the voting public, in order to make well-informed decisions. So terms of service enable the data collection economy. And the data collection economy, the surveillance economy, enables these disinformation and misinformation campaigns that have proven to be so destabilizing for our society. Not just in terms of our politics, but also our discourse, because it's gotten very nasty out there. And it's because the algorithms promote based upon popularity, on the things that will get people most engaged, which often means enraged. And so it's an appeal to the lowest common denominator, and that's because of the economics, which were shaped by terms of service. The result is a world where companies exercise enormous power. So there's the internet as it is now, but in addition to that, the terms of service give companies that have control over the data even more power, because now they can control the platforms and they're able to refer to the terms of service to exercise power over their users. The platforms that the public relies upon so much, depends upon, they have control, so they can cut you off if they don't like what you're doing. And this is a concern regardless of what side of the political spectrum you are, right? If the public depends on these platforms for their news and information, it can be problematic that who controls that information? Well, they're a profit-driven corporation. They're not, it's not the government that is supposed to have your best interests, society's best interests in mind. And nobody escapes the reach of terms of service, not even presidents or former presidents. Okay, so what will the future bring? There are a lot of open issues regarding how to regulate new technologies. There are issues surrounding the use of artificial intelligence. All that data that companies are vacuuming up is being used to create new forms of AI, okay? It's used to create better AI. Facial surveillance, what can companies do with the information they're collecting about you? Biometric data, I mean, that's data that doesn't change. And so what is it that they're going to do? What is it that they're going to be allowed to do? The fintech and these new sort of payment apps, what kind of fees can they charge? Autonomous vehicles, who's going to be liable when, you know, your autonomous vehicle crashes? Well, there are a lot of open issues, and we know from past experience that if there's a gap in the law, companies will try to address that gap by obtaining consent. And that consent may be in the form of a wrap contract or a digital contract that everyone knows nobody reads. And so one thing we can do is we can make a wrap contract or a terms of service an inappropriate vehicle for consent. Because of course we should regulate the substance of a particular business practice or the use of a particular technology. But just focusing on regulating the substance is a bit like playing whack-a-mole, because the technology is constantly changing. And there are a lot of reasons that so often regulation comes too little, too late. A lot of it having to do with politics and money and good, so forth. Suffice it to say, we also need to regulate the form in which consent can be obtained. Okay, so if we said that you cannot obtain consent via a click agreement, what would happen? What would happen is that if somebody found out about a particular new business practice or technology that was being used in a particular way, and they thought it violated their rights, what would happen or happens in other arenas is that they might sue, they might bring a lawsuit. And that doesn't mean that the practice is illegal. It just means that they are claiming it is. And the company would have to defend itself in a court of law, in a public forum, and it would play out in front of the public, okay, as opposed to in, behind closed doors. And so the whatever the decision is, whatever the practice is, people would there would be more attention drawn to it. It might also prompt regulators to act more swiftly. But that's not what happened with privacy, because the rhetoric of consent delayed a lot of this discussion until we got to the point that we are now. Because it's the pretense of consumer consent, which often stifles public discussion and debate until the practice has become so entrenched in a way that the public was not aware of. But there we are, here we all are, dependent on social media. And that's what we're seeing with social media and privacy. And I don't know if you have all been paying attention to the Facebook, what's been going on Facebook. And by the time it reaches that level, it's often too late to stuff the genie back in the bottle. So one thing we can do is not allow the online contracts to be a vehicle for consent.
Thank you so much, Nancy. That was fantastic. We already have some questions that have come in the chat. If anyone else has more questions, please feel free to type them in the bottom. So our first question is, the EU seems to have stricter policies around data privacy online. Is there a push for anything similar in the US?
This has been going on for years. What's interesting is privacy is one of those areas where there's actually been a bipartisan effort for years. McCain and, this was 15 or so years ago, there has been the political will among a group of senators and representatives. And there, in certain states, there has been. California recently passed a privacy bill. The problem has really been the way that so much of this discussion is wrapped up in conversations about free speech. Okay, but I think it's more than just than that. Which is often a disingenuous argument, as you can see from my one of my last slides. It was big tech, if it hurts their business, they're willing to cut you off, right? So it's not really, so that's not really, I'm not convinced that that's really what's going on there. But the reason there hasn't been more movement in this area is that there's so much money. There's been a revolving door between DC and Silicon Valley for years. And this is not a Republican Democrat thing. It's both, okay? And there's a tremendous amount of money. And I think that that's been the real issue, okay? And that's why there's been this, there's a law in California that passed, which is, it looks to be a pretty good law. And the reason they were able to get that passed is because one of the backers actually I believe is a billionaire. And so I think that it's going to be very difficult because Silicon Valley companies have so much money that unless, and on the other side, you have a collective action problem. So unless you have this somebody like a billionaire who really cares about privacy, it's going to be very hard to get that kind of traction. And culturally, we're very different from European countries where they might, they value privacy, whereas we value privacy as well, but we also the sort of free market and free speech rhetoric has really made it very difficult to talk about privacy in a way that isn't inflammatory.
So our next question, and I'm so happy that Olivia asked this because this was my own question. Have you found that there is a generational or age difference in who is or isn't skeptical of data privacy? She says, when she was younger, my parents were skeptical of the internet, and now much more often, I'm the one who has to stop them from sharing so much.
Yeah, so this is something that in some ways it makes me a little bit, okay, so let's say 15 years ago when I was talking about online tracking and cookies, I would present at conferences, and some of the other professors would say, what are you talking about? Are you kidding me? This isn't happening. They refused to actually believe this would happen because how is this legal? And then other people would come to me and say, notably, I remember a conversation with somebody who was representing one of the marketing lobby groups. And he said, people, they don't care. He tried to put it like, oh, no, that's an outdated view. Young people don't care. And if you go back, you'll find quotes from Zuckerberg and so forth saying, oh, no, we're all about sharing. We don't care about privacy. But I knew that wasn't true. Why? Because I know young people. And so that was very manipulative rhetoric. I think everyone cares about privacy. Nobody wants to be humiliated online. Nobody wants their intimate conversations, some random third person listening in on them. There are things happening that it would just make you paranoid to know that, oh, well, this couple was having a conversation in their home. Alexa accidentally dialed up the person they were talking about. So they heard the conversation. I mean, these are like nightmare situations. It's just that the companies don't worry, this is a generational thing, but we know it's not a generational thing. If anything, a lot of times maybe young people weren't thinking about it because the companies were really appealing to their impulsive nature. But once they find out what's going on, oh, they all moved to Snapchat, right? When they found out, once they came out with Snapchat, that was created by somebody young because they knew, they saw what was happening to their older siblings and they thought, none of that for us, please.
And I think Sandro has actually an interesting follow-up question to that. What are your views regarding why society continuously chooses to ignore reading the contracts to have immediate access to information they are searching for online?
So that's because if you read all the contracts that you're subjected to, you wouldn't be able to do anything else. There are so many. I actually tried to, you saw that I had quotes from different companies. I had to go and find, because they update them so often from when I put up the slides, and even reading through to verify certain things, it's impossible. I mean, this is what I do, and I was still okay. There's just so many links to the terms of service, and they refer to other terms. It's a fiction. It's a fiction. This is not actually a contract, because in the pre-e-contract world, it would never be the case that you sign a contract and then then the business is able to change the terms and then tell you to go down the street, open up the file cabinet there to read the rest of the contract. Because essentially that's what you're being asked to do with these hyperlinks. You're being asked to go to a different location to read another contract. It's not just a matter of it's a 1 or 2 page form that you read. It's much more complicated. And they've done studies saying that if you actually try to read all the terms in a contract on one website, it would take, I can't even remember how long, it's some obscene amount where you basically couldn't have a job or a life.
Yes, and Lily says, I've tried to read the contracts. They make it hard so you don't want to.
Yes, yes, absolutely.
And Sandro asked, do you think we choose to ignore reading the contracts because we tell ourselves everything will just be okay, and so we just click forward? Or what are your
I
thoughts
think
on
that there is that, as well as you don't really have a choice. I mean, if you read the terms and you didn't agree to them, you don't really have a choice. If you want to be on social media, let's say, or be on do online banking, anything, the terms are pretty much the same as far as the limitation of liability, the dispute resolution clauses. They're pretty much the same. And so you don't really have much of a choice. And so because of that, I figure, fine, I'll just, acquiesce to these terms and hope it's okay. Hope a dispute won't ever come up. I also think that you're right that because everybody else is doing it too, it feels like it's not going to be a problem.
Right.
But that is that's a cognitive like a trick, in the sense that you just don't hear about the issues with terms of service because they're not being debated in a public forum. They're being shunted into a private arbitration. So that's the other part of it, is that if people knew, oh boy, this is what happened, this is what happened to X, they shut this person's account without any reason, they, whatever the particular issues are, we don't know what they are because, and in fact, what we did discover, what we are now discovering, is some of the stuff that companies like Facebook and Google have collected about us. And when we find out, we actually don't like that. And we think, wait a second, but it's too late. I mean, how could we have gotten to this point where they have so much information about us, scanning your photos, scanning your emails. And it might seem like, okay, not a big deal, but if you saw it in the aggregate in front of your eyes, you might be embarrassed. All your purchases online, I mean, your text, it's just it does not make you feel good. So people just feel like it's almost like a not really believing that this could be the state of affairs. Like, how can it be that nobody is looking out for our interests like this, right? How is it that this is possible? And usually there are people looking out for interests and they sue in a class action lawsuit, but the terms of service have prevented that in a lot of cases.
Really interesting. I guess that kind of leads to my own question, is, I guess, what is the best way to protect yourself? Or is it actually possible to protect yourself online?
I think you can minimize the harm, but but there are going to be trade-offs. I have never been on Facebook, so that makes me an outlier, and I've probably missed out on things, but probably I've been much more productive too, is my guess. I haven't, and the reason is because I did read the terms of service, frankly, and because I knew about the data collection. I'm also not on Twitter, and that's maybe not a good thing for an academic. I mean, I should probably be on Twitter, but sometimes it's tough to study this in this area because you do have to make trade-offs. Okay, other things though that you could do without maybe going to that extreme is when you search, I use DuckDuckGo because even though I'm not doing anything terrible online, how do I put this? You're not doing anything terrible, but information about you can be compiled in a way that you might not like if there's a lot of information about you out there, if that makes sense.
Right.
And let's say, for example, you are, I mean, there's so many different types of scenarios, but if you're looking for, health insurance, is that going to come? Because it's not just the data itself, but it's the way it can be aggregated and how it can be used as a proxy for something else. I mean, of course you can't discriminate, but companies can use proxies. They can say, well, based on your purchases and who your friends are, we have determined that you are X and we're, so there can be illegitimate practices that are sort of accomplished by using data in ways that maybe we're not thinking of. And I'm also very concerned about the use of data in AI and surveillance.
Well, thank you so much. Let me just check. It looks like we don't have any more questions, but Sandra did suggest everyone watch The Social Dilemma on Netflix. I'm not familiar with that. But it looks like you are.
See that. Yeah, you'll see that and you'll say, oh, this is Professor Kim just touched the tip of the iceberg, right? But
right.
Yeah.
No, I've had Facebook for a long time and I'm thinking I should delete it now. Although at this point it may not help. But thank you so much. This was wonderful and so enlightening, I'm sure, for everyone. So just a reminder for everyone on the call, this presentation was recorded and it will be available on our website in the next couple of weeks. And then our next Alumni University session is on November 17th. Professor Calvin Nobles will be presenting, and that will be our last presentation for 2021. We will not have one in December. So we hope that you can join us. And thank you again, Nancy.
Oh, thanks. This was a lot of fun. Thanks.
So,
Bye.
thanks. Bye.